the issue of citizenship in India has been ongoing since the last many decades. And it has been at the forefront in India since 1947, that is since the time we have got independence. Over the last many decades, in one form or the other, this issue keeps on repeating itself.
Marching to the beat of their own drum, thousands of people defied a ban on public gatherings in the Indian capital, New Delhi. They oppose a recently passed law that grants citizenship to religious minorities from Afghanistan, Pakistan and Bangladesh.
The last decade especially has witnessed us moving from the jus soli principle, which is citizenship based on birthright on the soil of the country, to jus sanguinis, that is citizenship based on blood, descent, heritage or race. Particularly with the proposed amendment of National Register of Citizens and Citizenship Amendment Act of 2019. But today we are not here to talk about this. Today we are here to talk about a very special issue of Section 6A of Citizenship Act of 1955. Now, what is the whole issue about? So on 17th of October in 2024, Honorable Supreme Court of India, in a landmark and historic judgment, upheld the constitutional validity of Section 6A of Citizenship Act 1955. Now this particular section, Section 6A, grants citizenship to certain immigrants who came to the state of Assam between 1st of January 1966 to 25th of March 1971. So between these dates, the immigrants who came to India, the immigrants who came to Assam, would they be considered citizens or not? That is the whole issue of this Honorable Supreme Court judgment. Now the majority, comprising of D.Y. Chandrachud, that is the Chief Justice of India himself, and other justices like Justice Suryakant, Justice M.M. Sundaresh, Justice Manoj Mishra, they upheld Section 6A of Citizenship Act 1955. Now this act, or this particular section, Section 6A, it codified the political consensus of 1985 Assam Accord. However, one justice of Honorable Supreme Court, that is Justice J.B. Pardiwala, he dissented on this judgment. So this judgment was passed with a 4-1 majority. Now what is Section 6A? What is the judgment of Honorable Supreme Court of India, and why there is contention in relation to citizenship in Assam and that of India? All these things we'll be trying to understand in this particular session along with Assam Accord. Hello, my name is Preetpal Singh, you're watching Perspective, and today our topic is Section 6A of Citizenship Act 1955. Now, Section 6A is a special provision added through the Citizenship Amendment Act of 1985 in furtherance of a memorandum of settlement which is called as Assam Accord, which is between the central government led by the then Prime Minister of India, Shri Rajiv Gandhi ji, and the leaders of Assam movement. Now, this particular section conferred citizenship to those who migrated from East Pakistan, which is now Bangladesh, to Assam from 1st of January 1966 to 25th of March 1971 upon completion of 10 years from the date of detection as a foreigner. Now let us understand this issue and put things into perspective. In the late 1960s and early 1970s, political turmoil in East Pakistan was culminating into Bangladesh Liberation War of 1971, which caused a massive influx of immigrants into Assam. So a lot of refugees came into Assam from East Pakistan, which is now Bangladesh. Now this period saw one of the largest waves of migration in India after 1947, where millions crossed into India's border. So now the whole issue is around just one single question. The question is that those who immigrated to India from the East Pakistan, that is Bangladesh, during 1960s and 1970s, will they be considered as citizens? And if yes, then who will be considered as citizen and who will be considered as a foreigner or an illegal immigrant? That is the one question we're surrounding the whole issue. So everything boils down to the cutoff date which the government of India has chosen under the Assam Accord of the Section 6A of the Citizenship Amendment Act of 1985. So that is the whole issue. And of course, Section 6A tried to solve this issue by granting citizenship to those who entered into Assam in a particular cutoff date which we have discussed earlier. But this particular law and this particular section 6A was challenged in the Honorable Supreme Court of India. And what were the grounds of challenge that we need to understand? So several petitioners like NGOs, civil societies, including Assam Public's work, Assam Sanmeta Mahasangam, they argued that Section 6A, it is discriminatory and it violates the equality clause of the Constitution of India. And also they argued that it sets a different precedent, a different standard for citizenship in Assam compared to rest of India where the cutoff is July 1948. And also they said that there are several concerns in relation to granting citizenship to these migrants and them infringing upon the cultural rights of the indigenous Assamese people, which is enshrined in our constitution, which is protected in our constitution under Article 29, Section 1. Also, one more thing these petitioners argued. They said that this Section 6A, it challenges and violates the Article 326 of the Constitution of India, which provides election to the Lok Sabha and Legislative Assembly that should be taking place on the basis of adult suffrage. Now, they argued that the accommodation of additional citizens pursuant to Section 6A diluted the right of original inhabitants to exercise their adult franchise. Under all these different heads, they set different grounds for challenging this Section 6A. And on 17th of October 2024, Honorable Supreme Court of India gave its judgment. Now let us understand the judgment in a detailed way. This verdict, it takes a very liberal and expansive view of citizenship. The Chief Justice of India, Chandrachud ji, sets the tone by observing that the challenges regarding the constitutionality of statute requires the court to take a flexible approach. Now, Section 6A, as he and his three of the colleagues on the bench noted, was the legislative corollary to the Assam Accord. The task before the lawmakers was to balance the humanitarian needs of the migrants of Indian origin and its impact on the economic and cultural needs of Indian states. Also under different heads, Honorable Supreme Court of India gave its judgment. So on legislative competence of Parliament to enact such a law of Section 6A, it said that the law was enacted in exercise of the power under Article 246, which reads with entry 17 of List 1 under Union List. And entry 17 under Union List, it deals with the issue of citizenship, naturalization and aliens. So the Parliament of India is competent enough to enact such a law. That is the first thing. Now, second thing is in relation to right to equality. That is Article 14 of our Constitution. Now, Assam's special citizenship law, it does not violate the right to equality because the migrant situation in Assam was unique in comparison to rest of India. That is what the Honorable Supreme Court of India observed. Now, coming to the impact on culture, that is Article 29. The verdict said that there is no evidence that the migrants harmed the cultural rights of Assamese. Now, in relation to the cutoff date of 24th March of 1971, it is reasonable because the Pakistani army, they launched Operation Searchlight to curb the Bangladeshi nationalist movement in East Pakistan on 26th of March 1971. So migrants after this date would be considered as migrants of war and not of partition. And also the verdict said that this Section 6A is in alignment with India's fraternity goals and rejected the petitioners' restricted view of fraternity. Supreme Court also held that in India's case, fraternity is more broad-based and inclusive, and it is aligned to social justice goals rather than a narrow and parochial approach to fraternity. Also rejecting one of the arguments, the Supreme Court held that Article 326 does not provide for any group of citizens to seek exclusion of another group from the right to vote. So that is also rejected. And also eventually the Supreme Court of India said that Section 6A does not amount to external aggression. However, it is a controlled and regulated approach to migration. The verdict also said that as the migrant situation in Assam was unique in its own way in comparison to the rest of India, it was justified to create a new law, especially to address this issue, and doing so would not violate the right to equality under Article 14 at all. Also, Chief Justice of India D.Y. Chandrachud stated that mere presence of different ethnic group in a state is not sufficient to infringe on the right guaranteed under Article 29, Section 1. But there was one dissenting opinion and one dissent on the judgment, that is by Justice Pardiwala. Now, he in his dissenting opinion held that the provisions are unconstitutional. Section 6A is unconstitutional and suffered from temporal unreasonableness. He also suggested that it does not provide any prescribed time limit for detecting foreigners and determining whether they were citizens or not. This, according to him, relieves the government of the burden of identifying illegal immigrants and deleting them from the electoral rolls, which goes against the objective of providing citizenship while protecting the cultural rights and the political rights of the people of Assam. This is what the dissent note of Justice Pardiwala said. Okay, so now let us talk about Section 6A of Citizenship Act 1955 in a bit of detail. Now, as we all know, it was a part of Assam Accord 1985. But the question is, what is this Assam Accord? Now, Assam Accord is a tripartite accord signed between the Government of India, led by the then Prime Minister Rajiv Gandhi ji, the state government of Assam, and the leaders of Assam movement in 1985. Now, the signing of this accord led to the culmination of 6-year-long agitation by, that is, All Assam Students Union (AASU), which started in 1979 and demanded the identification and deportation of illegal immigrants from Assam. Now, this Assam movement, which is an anti-foreigner movement also, from 1979 to 1985 was a popular uprising in Assam. And it demanded the Government of India to disenfranchise the illegal immigrants who entered Assam. Now, we have already discussed that the Section 6A of Citizenship Act 1955, it grants citizenship to immigrants who entered within a particular cutoff date. That is, those who entered into India from 1st of January 1966 to 25th of March 1971 can be conferred citizenship if they prescribe or if they fulfill certain prescribed criteria. However, this accord and this section, it denies citizenship to those who entered India afterwards, after this cutoff date. Now, since we have already discussed that why certain sections of the population in Assam are against this, let us quickly summarize the points in detail. First is in relation to violation of constitutional provisions, especially the right to equality under Article 14. Second thing was that these petitioners said that the cutoff dates is arbitrary and there is no logical reason or there is no logic and rationale behind setting up this cutoff date. And third is that it violates the cultural rights for preservation of the Assam communities. Also, fourth is it facilitates external aggression, and the last one is that it is against the goal of national fraternity. Now, all these issues have been dealt by the Supreme Court of India's judgment, which we have discussed previously. But one thing to note here is that why this judgment is so significant and so critical for the whole citizenship debate which is going on in the country. First thing is that it provides a comprehensive judicial examination of citizenship. The Supreme Court's verdict on constitutionality of Section 6A is a comprehensive judicial examination of citizenship under Indian Constitution, and it also gives a liberal and broad view of citizenship, which is again a plus point and a significant event in our constitutional history. This judgment has enforced that citizenship is a broad and plural concept and rejecting the narrow interpretation of citizenship based on cultural exclusivity. Now, these observations are crucial to form the backdrop of some other constitutional challenges involving citizenship in India that is pending before the Honorable Supreme Court of India. That is the challenge to the 2019 Citizenship Amendment Act. Now, this contentious new law seeks to introduce Section 6B to the Citizenship Act of 1955. Now, the CAA, it carves out an exception for tribal areas of Assam, Meghalaya, Mizoram and Tripura, as included in the 6th schedule of our constitution, and the area which is covered under the inner line permit. Now, this amendment was also challenged in the Honorable Supreme Court of India, and since then, several petitions have piled on in the Supreme Court of India to challenge this particular law. Now, this new judgment will have a significant impact on how this new law is seen by the Supreme Court of India, and will it be upheld constitutionally or not. Both the centre and the Assam government have claimed that Section 6A has served its purpose, and it was passed in a peculiar situation following the Assam Accord 1985 to quell the violent protests which were going on in the state. The Section 6A is a part of the legislative policy of the Parliament, arising from a political settlement with relevant parties based on certain relevant considerations during that period of time. So in such matters, it will be very difficult in determining judicially manageable standards to judge the constitutional validity of the same. This is what the center, that is the central government, has to say about this issue. And now, because of the judgment, now this issue can be put at rest because Section 6A is upheld constitutionally, and the Honorable Supreme Court of India has dismissed all the arguments which were against this Section 6A, and they have reiterated that it was during a peculiar time, peculiar situation, and that is why at that point of time it was necessary. See, citizenship has been the most important and extremely sensitive issue in almost all the democracies throughout the world, and India is no exception to this. The topic in itself is very vast and very wide. In today's discussion, we have covered this recent Supreme Court of India's verdict. However, if you need a separate video on citizenship issue as a whole, I'll be very happy to make it. Please let me know in the comment section what are your views surrounding this issue and how could this judgment impact the upcoming judgments in relation to citizenship in our country. All the very best and have a very beautiful day. Stay safe, take care.